Do you have a tenant who is not paying rent and you want to evict them but you don't know how? Over the next few minutes, I'm going to provide you with some information on how to terminate tenancy for non-payment of rent. Because the process can be overwhelming, I've put together a free cheat sheet that you can follow. Drop me a line below and I will send it to you. No email or opt-in of any kind is required. This is my gift to you for watching this video. For those of you who don't know me, my name is Vida Delisi. I have a background in real estate and property management. I'm a landlord myself, and I'm the owner of Stonegate Legal Services. I have helped hundreds of landlords with their issues with tenants, and I want to help you with yours. In every single video, you're going to get at least one strategy that you can implement in your business as a landlord. In this video, we're going to talk about the N4 Notice of Termination of Tenancy for non-payment of rent. The N4 can be served from a landlord to a tenant the day after rent is due if the tenant does not pay. This notice has a 14-day termination period. And what that means is that it provides the tenant with three options. Number one, the tenant can pay to stay. Number two, they must move out by the day of termination. And number three, they don't have to do anything and the landlord has to apply to the landlord and tenant board to evict them. There are 5 ways that this notice can be voided. Number one, if the landlord does not apply to the landlord and tenant board within 30 days after the day of termination. Number two, if the tenant pays the arrears before the 14-day period. Number three, if the tenant pays before the hearing. Number four, if the tenant pays on the day of the hearing. And number 5, if the tenant pays before the sheriff arrives to evict them. The landlord can then apply to the landlord and tenant board by way of an L1 application to start the hearing and eviction process. When the board is in receipt of the L1 application, they will serve a notice of hearing, video or telephone hearing. If you are a party to a hearing, you must attend your hearing, or you must send a legal representative to attend on your behalf. If you don't attend your hearing, and if you don't send a legal representative to attend on your behalf, your hearing will resume without you and you will not get a favorable outcome. On the day of the hearing, the tenant can raise issues under Section 82 of the Act. And Section 82 of the Residential Tenancies Act allows a tenant to justify the reasons, issues, or concerns as to why they haven't paid the full rent or partial of the rent. Some examples can be if the landlord is not tending to maintenance concerns, if the landlord is not making repairs, if the landlord is requesting illegal deposits. These are some issues that can be raised on the day of the hearing. Tenants can also raise issues under Section 83 of the Residential Tenancies Act with respect to delaying an eviction. An example of this can be if the tenant is a single mother and she cannot afford to move during the winter time, then the board will take this under consideration and either delay or deny an eviction. On the day of the hearing, a landlord must show the board that they have accommodated their tenant. And what that means is that the landlord must show the board how many times they've reached out to the tenant to request a repayment plan. If the landlord can show that the tenant has not responded, then the board will either issue an eviction or the board will put together a repayment plan on the spot. If the tenant has responded positively, however, a fixed amount cannot be agreed upon, then it's up to the board as to what amount is reasonable. Again, because the process can be overwhelming, I've put together a free cheat sheet that you can follow. Drop me a line below and I will send it to you. No email or opt-in of any kind is required. This is my gift to you for watching this video. If you have any questions, call us first.